is clear that there's some overlap between research ethics and privacy law, particularly in the area of confidentiality relating to the information that you obtain from research informants. And in this video, we're going to have a bit of a look at the Australian privacy laws to give you some idea of where the overlap is and where the difference is. Of course, one key difference is that privacy law is an externalised legal set of requirements, and research ethics, while they relate to national codes and so on, are ultimately an internal voluntary set of regulations. Now, Australian privacy laws have their origins in the regulation of government-kept information. And if you've studied in administrative law, you'll know there are a whole lot of reforms and changes to the way that government was administered in the 1970s and 1980s, and this was part of it. It's important to note that these are information privacy laws. They cover privacy in relation to actual information that's kept and how it's handled, not privacy as a more general concept. Now, these laws were first created at the Commonwealth level, but were soon followed by state legislation that covered similar activities under the same principles. Now, at Commonwealth level, or at each level, these are administered by information commissioners, and the Commonwealth version of this is currently the Office of the Australian Information Commissioner, and each of the state jurisdictions will have something similar. And these portfolios include a range of different things, including privacy, freedom of information, regulation of direct mailing and spamming, and so on, that have all been put together into one department. Now, who's covered by these laws? As I said, originally they were government only, but they got expanded quite dramatically to cover other organisations. So it does cover all government, it does cover public organisations. It now covers private organisations that are large. So the benchmark is an annual turnover of $3 million or more. But also there are other organisations that are smaller that can be covered. So if you have any confidential health information, whether you be a medical practice, a gym, a chiropractor, a crystal healer, a school, a daycare centre, you are also required to comply with the Act, even if your turnover is not $3 million. And there are a few other prescribed businesses, so if you're in doubt, look it up. And there's always an option for organisations to opt in to the Act. They're quite happy for you to be able to say, well, we aren't covered by it, but we're happy to comply with it. So there's a regime and there's a set of national Australian privacy principles, which we'll come back to, that govern the way in which information is used. Now, that can be contrasted to the common law tort of privacy, sometimes called the tort of invasion of privacy, which provides a remedy for people whose privacy is violated. Now, up until recently, that law has had a fairly uncertain position in Australian law, and at the moment the best we can say is that there's strong obiter dicta indicating that there's a move towards national recognition of privacy law. And there was for a very long time a precedent that people said that the tort of privacy didn't apply in Australia. When you look very closely at it, it's actually that statement is itself obiter. It's not part of the core part of the case. So there's a couple of jurisdictions in Australia that have recognised privacy at common law. We're yet to have a High Court determination on the matter. And it's one of those issues of, well, what is invasion of privacy generally? It's whether harm is suffered without any direct trespass. So one example is someone is peering in through your windows. They're not actually on your property, but they're looking in through your windows. And without a tort of privacy, your only remedy is to close your curtains. This is becoming a lot more complicated with the rise of things like drones. And I think that is going to see some significant developments in privacy law coming up relatively soon. So let's put that aside for the moment and say that the kind of privacy law that we're looking at here is under the government regulatory schemes, and it's purely about information itself. It's not about you feeling that your privacy has been invaded or any of those more abstract things that the common law would cover. So there's a set of Australian privacy principles, and you can get these on the Commissioner's sites, and they're written reasonably straightforwardly and not in legalese, but they cover things like the identification of individuals within your research or by organisations in generally. And that can also cover where you identify someone by context, where you don't name them, but the information about them is so clearly about a specific person that, or a small class of people, that they can be identified. So obviously identifying someone and handing out their private confidential information is a bad thing. But the principles cover other things, such as always giving an option for anonymity where possible in any interaction with personal information, good quality record keeping, keeping your information secure, and destroying information where you don't need it anymore. It also involves being clear about the purpose of collection and not using information for purposes other than for which it has been collected. So no deceit and misleading when you collect information and saying, we're collecting information about this, and actually surreptitiously using it for a different purpose. There's also principles on how you can use information, whether you can put people on mailing lists or not, and the requirement to have consent for that. The principles also give individuals the right of access to information and the ability to correct information when it's wrong, which is surprisingly often even with very important government information. And there's been a lot of people before these principles applied who spent a lot of time trying to correct a piece of information that government was held that just simply wasn't true, that was a mistake. But of course the government says it's on our database, it must be true, when even though it clearly is not the case. And there are many other things in those principles, but another one is it requires these organisations to have a privacy policy. And I think that's a very interesting form of regulation. It's away from the here's the thing you do, and if you do it wrong, we punish you for it. And it's saying we are requiring you, and we'll punish you for it if you don't do it, we're requiring you to be proactive. We're requiring you to have a policy, to have it public, to have it accessible, and to be open about it. And I guess also then to change your culture in relation to privacy, and to make sure that your organisational culture meets that. Now, I think all those conditions are very congruent with the codes of research ethics. The other thing that the Australian privacy law covers is more stringent requirements when dealing with sensitive information. So health records, ethnicity, politics, religion, sexuality, criminal records. Interestingly, also biometric information. These things have a higher status and a requirement for more stringent measures in handling that information. Now, some of those are also included in the research ethics guidelines, but they're not exactly the same. So it's interesting to see where there is some mismatch between those two forms of regulation. Now, the remedies under the privacy law are things that I'm hoping you won't have to worry about. Hopefully, if you are following good ethical practice, you won't get to the point where we're worried about what sort of penalties you're going to apply. But the information commissioners have the power to investigate, and they have the power to enforce what they call enforceable undertakings, where they say to organisations, you've done wrong, what are you going to do about it? They undertake to say, well, in the future we're going to do this and this and this. It's created as a formal document, and if you breach that document in the future, there are more severe penalties than if you go to court. So again, the approach of the privacy law is less towards hitting people with sticks, but giving people a chance to fix up and remedy what they do, and then having in the back pocket a much more stringent set of enforcement mechanisms if at the end of the day they're lying about that, or they're neglectful, or they're slack, or whatever, and saying, well, actually you said you were going to do this, so now we're going to punish you for doing it. So that's the two fields. Obviously there are other interactions between research ethics and law. The fact that you have promised confidentiality to a subject does not protect you from a subpoena. If you are then subject to legal proceedings, you're not someone who can stand up and say, my information is privileged, I don't have to disclose it. You can be punished for contempt for refusing to disclose that information. And there are also situations where there's mandatory reporting, particularly involving criminal activity in children, that you need to be aware of if you're researching in those fields, where again, the fact that you have a duty to protect the confidentiality and anonymity of research subjects is trumped by some other more important legal right. And the final thing I want to think about and suggest that's a matter for further discussion is, what is the status of privacy in the social media age? There is some argument that people don't value privacy anymore, that the kind of information that governments used to try and compel out of individuals, people are now publicly putting on Facebook for everyone to see, and that somehow privacy is dead. But I think I agree with what the Information Commissioners say about this, is that privacy is actually more urgent than it has ever been before. And the fact that people willingly surrender so much information doesn't mean they're really doing that with free knowledge of the consequences, or freely doing that with an understanding of what their legal rights are. So privacy is an area which I think is going to become more important. And the fact that its status is not what it used to be, and the fact that it is in such peril, I think is a strong argument that it's an area where we need to focus on it more and more than we ever have before.